Everybody, Rich down here in the bunker. Hey, it is Sunday, and what we're going to do is bring back one of the features that we used to have, gosh, a year or so ago when everything was going crazy with, different legislations for firearms and stuff that like that throughout the state and throughout the country. Um, when they were really pushing in Illinois to totally change the FOIA Act, totally change CCL, and we would have our firearm legislation updates. Well, what we're going to do, and it won't be every Sunday, but on Sunday, we will do a firearm legislation update for you. Okay. Um, Gathering information from all over the country, all over the states, federal legislation, and also state legislation, and keep you abreast of what's going on with different lawsuits that are going on in your state. If you have an interesting one that you'd like to send me that we could add to our Sunday firearm legislation update, please do so. That would be very great. And then I could look into it and mold it into our Sunday feature. So, like I said, it won't be every Sunday. We'll get it in as often as possible. And if something breaks that's really crazy, we will obviously put one out there for all of you to know. Some of the stuff that we're going to talk about today is a little redundant. Some of the stuff is new. So let's get into it. For this Sunday firearm legislation update, what I want to key in on is where we're at with the Protect Illinois Communities Act in Illinois. Okay. Where we are at this point, we have 4 temporary restraining orders in the state, 2 in Effingham County, 1 in White. Those were all put forth by Attorney DeWine, and then 1 in Macon County. So the 2 in Effingham and the 1 in White County covers 4,713 individuals and 148 FFLs. The one in Macon County, there's several named people, but there's also the group called the Law Abiding Gun Owners of Macon County, and they figure there's about 2,100 people within that. And what's interesting, especially in the after the state appealed the one TRO in Effingham County, they really aren't putting up much of a fight. They're just kind of laid back. A lot of people are suggesting that they're holding off to really kick it in when it goes to the Illinois Supreme Court. Um, so there's also talk, the state has asked that these federal cases and the state cases, federal all get put together, state all get put together for, just to reduce some of the cost of these cases. The interesting thing, and I guess it's nice to combine those because not only are we, the plaintiffs and the attorneys and stuff like that, well, the attorneys aren't, they're getting paid, are spending our money to fight this, the state is also using our money to fight this. It's a lose-lose situation as far as tax dollars, so they're just, wasting both. Um, from what I hear is many of these cases will be heard the first part to the middle of March. So that's where we're at with all those cases. After the hearing in Macon County, Representative Dan Calkins of Decatur stated, "The patchwork of TROs is unfair to all of the citizens of Illinois." Calkins' attorney, Jerry Stocks, said that they plan to go the next step and ask for a statewide TRO. And their next time that they're going before their status hearing is on March 20th. And that's one of the things that they want to bring forward, that to try to make the TRO across the state. During that time, the attorney for the state basically said, well, we don't believe that the judge has the authority to do that. So we'll see. We'll see on March 20th. The ISRA officials also stated that gun dealers have plans to submit a separate lawsuit to deal with the magazine ban only. So that's coming forward. We'll know more about that. So here's a little sidebar, and there was a little flare-up in DuPage County between some officials and citizens and the sheriff there, Jim Mendrick, about him changing his stance on enforcing PICA. So, and this basically what he said was he has not changed his stance on the not enforcing the law. He said he is not and will not be going door to door or enforcing the gun and magazine ban, but will enhance penalties for those that use these firearms in crimes. So basically, what he's saying is we're not going specifically after this. We feel it's unconstitutional, but if someone commits a crime in and has these magazines or these firearms, that will be an added charge. So that's where they're at. He has not changed his stance on that at all. And like we've said before, that over 90 county sheriffs said the same thing. And Jasper County Sheriff Brandon Francis went so far as stated that his oath is to the Constitution and not to the governor. Go Brandon. Let's go Brandon. We had a question from a subscriber. They took a look at the original lawsuit against the firearm and magazine ban, and one of the items in there was the 3-read rule. And they said, well, I've looked at this. It looks like they've read it 3 times, so I don't understand where they're coming with the 3-read rule. And we know that in the appellate, they kind of tossed that out as using that for a TRO, but it's still in there. So the subscriber asked, well, why is that in there? Well, here is why it's in there. Okay, so you have the 3-read rule and what senators and representatives call the gut and replace. And what a gut and replace is, you have a initial bill, and then you start with that bill, and then you decide to, let's pull this section out and put this new idea in. That's gut the original bill and replace it with something else. And then in the 11th hour, you change the name of it, or you don't change the name of it. So the bill was read as a change to the Illinois Code 3 times in the House, the original time, 2 times in the Senate, and then it was gutted and replaced with the PICA part of it, and read the 3rd time in the Senate when it was passed, and then it was sent back to the House, and then the House approved the changes and read it with the new bill. That's what they're going after. So for those of you that are wondering why the 3-read rule was brought up, that's why it was, because it wasn't read as the original or the final bill. Legal experts say there's little chance for a law to be nixed based on the 3-read rule. But I think it was just in there because it was just in there. We've reported on this before, that the U.S. Senate has a Bill 214, which is the Concealed Carry Reciprocity Act. And now the House has H.R. 38 is going into effect. We're going to talk about that in a second. I got another piece of paper here. Other cases across the country. There was a case that was brought forward to the U.S. Court of Appeals for the Fifth Circuit. A gentleman who had a domestic violence order against him had his firearms taken away under the red flag laws. The Fifth Circuit said you can't do that. If it's just an order and you have not been convicted of domestic violence, you cannot have your firearms removed. Good or bad, that's the rule. What legal experts are saying that this could affect red flag laws across the country, okay? That you have to be convicted of domestic violence before you can have those firearms removed. In Oklahoma, U.S. District Court had a case of somebody that had a medical marijuana card, and the state police said you cannot own firearms. Well, U.S. District Court in Oklahoma said no. Being a marijuana user, be it either for recreation or for medical, is not just cause to lose your firearms or your firearm license. So again, that could affect many, many states. This whole thing is crazy between the states allowing marijuana, and then, technically in 4473, it's not allowed because it's a controlled substance as far as the federal government goes. So a lot of these cases that are coming forward are being based on the New York gun club bill that was against Bruin decision, where it stated that courts can no longer balance public safety with fundamental rights, but must rule on the text and tradition of the Second Amendment as a supercharged right. And a lot of the courts are taking this into effect. All right, so let's jump back to Illinois here a little bit. And the National Rifle Association filed a suit in Southern Illinois federal court. And the attorneys they're using are the attorneys that fought the U.S. Supreme Court decision striking down state handgun restrictions in New York. So these guys are headed by former U.S. Solicitor General Paul Clement and appellate lawyer Aaron Murphy. So that's good for us. These guys know the law, they know what's going on. And basically, they said it further forced the government to prove, in this case, which was a New York State Rifle and Pistol Association versus Bruin, it further forced the government to prove that its regulations are in keeping with the nation's history on firearm regulation and is not a new affront to the right or keep and bear arms generally guaranteed under the Second and 14th Amendment. All right. So in that lawsuit, NRA and IGRA both argued, now in this case, sorry, I kind of got that goofed up, in this case argued that the General Assembly simply chose to ignore the Supreme Court's ruling and enacted the Illinois law, known as HB 5471. It is clearly unconstitutional attack on law-abiding Americans' rights. Illinois enacted the Firearm Ban Act, a statute that completely bars plaintiffs from acquiring, transferring, possessing, or repairing hundreds of types of firearms. Well, we know that. So what the lawyer said, fortunately for the plaintiffs and the average everyday law-abiding resident of the state of Illinois, the U.S. Supreme Court has repeatedly taught us that gun laws in the country can only withstand review if they are consistent with a broad and enduring historical tradition of firearm laws regulating certain types of persons. Okay. The Supreme Court made it clear that when the court confronts a flat ban on possession of a type of arm, the only question is whether the arm is at issue is typically possessed by law-abiding citizens for lawful purposes. The NRA said, quoting the U.S. Supreme Court 2008 decision in District of Columbia versus Heller, an earmarked land decision upholding the Second Amendment rights. So, and we all know that the firearms that they have said that, the ban in the state of Illinois are typically possessed by law-abiding citizens. If the answer is yes, then the ban is unconstitutional because the state cannot prohibit ordinary law-abiding Americans from possessing what the Constitution entitles them to keep. Because modern semi-automatic rifles and hundreds of other arms banned under HB 5471 are arms in common use today, they are protected by the Second Amendment, full stop, rendering Illinois efforts to flatly ban them flatly unconstitutional. All right. So basically, in short, there is no enduring American condition of state regulation forbidding the purchase and or possession of semi-automatic rifles and pistols by law-abiding citizens for lawful purposes. To the contrary, the enduring American tradition is one of protecting the right of the people to possess firearms that, like semi-automatic rifles and pistols, are typically possessed by law-abiding citizens for lawful purposes. That's why I've said all along that this is going to go probably all the way to the Supreme Court to get that figured out. All right. So, but it's really good. We've got these guys in there. We've talked about that before, and it is good to hear. Hey, let's talk about the Illinois State Rifle Association. Here's my disclaimer. They are not sponsors. Probably won't be. They're doing very well on their own. But we've talked about different lawsuits that are going on in the state, but here's some just to remind you of what the ISRA is doing. Obviously, they have Harrell versus Rowell, which is the case we just talked about, was Pico. You have Sedniker versus Will County State's Attorney, which is a petition for leave to appeal, is currently before the Illinois Supreme Court for non-resident FOID restoration. Meyer versus Rowell, which is a CCL case. Then you have Schoenthal versus Rowell, which is a public transportation CCL case, basically saying that, hey, we should be able to carry on public transportation. Singleton versus Kelly, it's a FOID appeal delay case. We have Levine versus UL LLC, The plaintiff was fired allegedly for storing a CCL firearm in a company parking lot and was fired. That's another case the ISRA is dealing with. Atkinson versus Garland. This is a federal felony restoration. It was dismissed by the district court and argued to the Seventh Circuit, waiting for decision. Then you have Miller versus Smith, which is foster home daycare firearm prohibitions. All right, and that is in summary and going to the Seventh Circuit for briefing. All right. Other things that we're talking about is, Florida House Bill 543, which is constitutional carry. That's coming. Now we're going to go back to the concealed carry reciprocity thing that John Cornyn and Bill Hagerty introduced in Congress. Basically, this bill would allow the right to keep and bear arms across the nation. First, it does not set a national standard for the right to carry. Second, if you have a concealed carry license in your state, you can carry the same as if you were in your own state. Third, it would treat state issued licenses like driver's license so that they would have to be recognized by every state. Okay, like we said, this started in the Senate. It is now in the House also, which is really good to know. Couple of things else. USCCA sent out a notice about that Senate and House bill. And then for those of you that know about Rock Island Auction Company, they sent out this nifty little thing. It says, notice to non-exempt Illinois residents regarding the Protect Illinois Community Acts. And it's talking about that if you are a plaintiff and you are covered under the TRO, you can come here and you can purchase a firearm. So there you go, in auction. So that's it. There you go. There is your Sunday firearm legislation update. I hope this answers some of your questions. If you got more questions, let me know about those questions. If you have anything to add, if you are in a different state and you've got some really cool stuff coming your way, I mean, we're finding out about the firearm and magazine ban in Michigan, New Mexico, Washington, Oregon, and stuff like that, and see where they're all heading. I think this latest case with the U.S. Supreme Court, the New York State Rifle and Pistol Club versus Brune, may make a lot of changes, but a lot of legal action, a lot of state money, and a lot of personal money going for ridiculous lawsuits. So keep your spirits up. We will prevail, and we'll see you on the next update. Take care. Bye.